So first of all, with respect to the Attorney General, given the fact, Mr. Reichel, that you've worked so hard on this and know the details of the law, I just want to reiterate, as Flo has said in the reports that have been filed, and we'll probably say it again in the report we'll file before the 19th, that the Submerged Lands Act application that's pending for the anchor supports raises a very substantial question. And I guess what I'm saying, Mr. Roycraft, is also applicable to the DEQ here because of the Submerged Lands Act. Specifically, the Act requires agreements, occupancy, and permits for structures and improvements on the bottomlands of the Great Lakes. That application should be subject to those provisions because the anchor supports are structures, and I know they've been viewed in some respects as just a repair, but in fact, at this stage, and now that we know what happened in early 2000 and on from the documents disclosed in June, we know that the pipeline design itself has failed. It isn't working, and this is a new way to address it. Up till then, it was grouts and hoping that the scouring wouldn't happen from the storms. So you have a direct, inextricable relationship between anchor supports, which are new, and a pipeline structure itself, which taken together is in such a dangerous condition or uncertain condition that you have the power under the Submerged Lands Act to require those applications, treat it as a full-blown review for an occupancy agreement, and then apply the rules, including Rule 15, which requires a full-blown impact analysis of potential impacts beyond the likely impacts, and no permit can issue unless there's a showing of no feasible and prudent alternative, which gets you finally in a position to put Enbridge under the rule of law and under the gun to start doing their job and have them carrying the burden rather than the people in the state of Michigan and yourselves. It's time to shift the burden of proof and put it on Enbridge. You can draw the line, put the stake in the ground under the Submerged Lands Act, and get all of us into a place where we'll be under a process that will bring all of the evidence out into the open rather than a ping pong match that we're all faced with because of the somewhat advisory nature of the process that's going on now. The second thing I'd like to say is, Director Cray, I think the power you have as holder of the easement gives you a broad power to revoke, not to terminate it. Underneath all of that, at all times, there's an implied right under case law that you can always revoke an easement because the easement of public trust bottomlands is not permanent. It's more in the nature of a privilege and a use subject to the power of the state under the public trust doctrine. Director Broder, since you have control of the Michigan Public Service Commission, or at least have oversight of that, that's what it says on the description of the agency. But I know they stand alone under the law and the Constitution. But if you can influence them, so far the state of Michigan has allowed Enbridge to piecemeal both Line 6B's replacement with the 800,000 barrels, and the DEQ and the Public Service Commission allowed the anti-injection devices to increase the volume from 300 to 540,000 barrels in Line 5, again piecemealing it without an impact and alternative analysis looking at the alternatives. Enbridge has piecemealed you, and piecemealed us on this. They have violated the law in doing it. The decisions of the Public Service Commission have violated the law because Enbridge didn't do it, and the Submerged Lands Act increase in volumes have violated the law because they didn't do it. The alternative has to be corrected. Right now, it's a violation of the law, and I'll end by just zeroing in on what I think is the real crux of the problem with the alternative study. The real crux of the problem is, and it's mirrored by the governor's agreement, that it tends to narrow everything down to a new line, a trench, a tunnel, or a ditch in the straits without looking at the combination of routing and alternatives as recommended by the resolution from the Pipeline Advisory Board 2 days ago. This is the crux. The DR defined by themselves that the alternative of other existing infrastructure was going to be limited to something equivalent to the existing volume of Line 5, which precluded looking at all the lines coming in and out of Michigan in a systemic analysis, which is required by the law. And after all, the task force report, which Bob Reichel, you did an excellent job of drafting, suggests, if not states, that the law requires a comprehensive alternative analysis. It's time it happens, and I submit that if you do that, we're going to get to the right solution, and most likely Enbridge is going to have to be suspended and eventually decommissioned with respect to that line, and we'll be on to a solution for Michigan's future without endangering the Great Lakes. Thank you.